Equitable distribution for high-value assets. What you need to know. Dividing property in a New York divorce becomes especially complex when the marital estate includes businesses, professional practices, real estate, investment portfolios, and retirement accounts. High-value assets require careful classification and valuation, and the goal is a fair, not necessarily equal, distribution. Because the outcome shapes both spouses' financial futures, guidance from an experienced lawyer is essential. New York's equitable distribution scheme starts by classifying property as either marital or separate. Marital property generally includes assets acquired during the marriage, while separate property refers to assets a spouse owned beforehand or received as an inheritance or gift, or that are covered by a prenuptial or postnuptial agreement. Assets acquired during the marriage are presumed marital unless a spouse proves otherwise. Mixing separate and marital funds or changing the title of a premarital home can change the assets classification. Courts sometimes divide increases in the value of separate assets if they result from marital efforts, while market-driven gains usually remain separate. After classifying property, judges divide marital assets equitably. They consider factors such as the spouse's incomes and property, the length of the marriage, age and health, contributions to the marital estate, the liquidity of assets, future financial circumstances, tax implications, and other relevant facts. There is no rigid formula, so the outcome depends on the facts and how they are presented. Both spouses must file sworn financial statements, and restraining orders prevent the transfer or concealment of marital property during the case. A skilled attorney can help shape the narrative and protect a client's interests. Determining the value of complex assets often requires outside professionals. Businesses and professional practices are appraised using methods that analyze comparable sales, projected earnings, or net assets. Courts typically acknowledge the contributions of the spouse who operates the business, so the other spouse may receive a 20 to 40% share. To preserve viability, judges usually award the entire enterprise to the titled spouse and compensate the other spouse through a distributive payment. Investment portfolios and stock options are valued using a date selected between the divorce filing and trial. Options granted for past services are marital property, while those for future work may be separate. Portfolios may be divided by splitting shares, buying out one spouse's interest, liquidating and sharing the proceeds, or offsetting them against another asset. Retirement accounts accrued during the marriage are marital property and can be divided with an order that directs the plan to pay benefits to the non-employee spouse. Real estate covers the marital home, vacation properties, and rentals. A spouse who uses separate funds for a down payment usually recovers that contribution before the remaining equity is divided. Courts distinguish between active appreciation driven by marital efforts and passive growth due to market trends. Only the former is typically subject to division. Complex divorces often rely on forensic accountants who trace money, distinguish between separate and marital property, and look for hidden assets. Concealing or undervaluing property can backfire. If discovered, a judge may award a larger share of the estate to the innocent spouse. Transfers of property between spouses in connection with a divorce generally do not trigger capital gains taxes because Internal Revenue Code Section 1041 treats them as non-taxable, and the receiving spouse inherits the asset's tax basis. Marital debts, mortgages, car loans, and credit cards used for family expenses are divided fairly, while debts tied to personal misconduct may be assigned to the spouse who incurred them. Because there is no simple formula for dividing high-value assets, thoughtful planning and precise valuation are essential. A knowledgeable property division lawyer or attorney understands how to present evidence within the statutory framework and advocate for a fair outcome. Choosing a law firm experienced in complex divorce ensures that assets are properly valued, separate property is protected, and hidden assets are uncovered. The law office of Richard Roman Shum, Esq. is a law firm equipped to handle high-asset divorces. Located at 20 Clinton Street, FRNT 5D, New York, 10002, and reachable at 646-259-3416. They provide the guidance needed to navigate equitable distribution. Contact this lawyer to schedule a consultation and protect your financial future.